A Canadian judge has temporarily halted the deportation of a non binary U.S. citizen over rising LGBTQ safety concerns in the U.S. 24-year-old Angel Jenkel arrived in Canada in August 2022 on a visitor visa and overstayed to support their fiancé, who requires full-time care due to epilepsy. Jenkel's removal was scheduled for July, but a judge ruled that an immigration officer's assessment failed to account for the current hostile climate towards transgender and non-binary people in the U.S. Federal Court Justice Julie Blackhawk describes the original risk assessment as flawed and unreasonable, citing its reliance on outdated information and inability to reflect escalating U.S. anti-LGBTQ policies. Our correspondent Adam Zivo joined us for more on this case.
Now, why did the judge rule the risk assessment to be flawed?
Okay, so let's get into the context here. So Angel Jenkel is a non-binary American who came to Canada back in 2023, I believe, or no, late 2022, and they came on a visitor visa that lasted for 6 months. So they were supposed to leave in February of 2023, but they overstayed their visa to take care of their partner, who was now their common law spouse, as he had developed a severe form of epilepsy with grand mal seizures. So they could have gotten married during that period or applied for PR, but they were irresponsible and didn't do it, which is kind of understandable because Angel's 24 years old. So obviously maybe not the most cognizant of immigration needs, but they were called in for an interview back in February of this year, and Angel received a deportation order 1 month later. And so what Angel did is they applied for what is known as a PRRA, a pre-removal risk assessment. And this mechanism prevents someone from being deported if that individual can show that they have a reasonable fear of persecution or harm back in their home country. Now, I want to clarify that a PRRA is not the same as a refugee application. It's a bit broader. So you can get protection either if you can show that there are specific harms that you face that are personal. For example, one guy got a PRA after he could show that he faced potential gang violence back in El Salvador and that he was being targeted specifically. Or you can show that you generally fit the definition of a refugee, in which case you don't have to show personalized threats. You just have to show that the minority group that you're a part of is persecuted. And if you can show that, you get protection, even though that's not technically refugee status. So Angel applied, they argued for both forms of protection, and ultimately the immigration officer who was overseeing the case said that Angel was not unable to meet either criteria. So I think that's pretty reasonable, but the immigration officer made a procedural error here. And essentially, what happens is that for any immigration officer who is reviewing a PRRA or a refugee case, they have to, look at the facts on the ground of the country of origin. And they receive something known as a NDP, a national document package, which provides some base level of knowledge of various countries. And these packages are updated cyclically. And so the immigration officer just cited NDP from early 2024 and didn't look at more recent circumstances in the United States with respect to the US's policies on trans and non-binary people. And NDPs are not supposed to be exhaustive. Officers are encouraged to do their own fact-finding, especially if the circumstances in a country are changing quite rapidly. So the proper procedure would have been for the officer to review the more recent statements and reports about Trump's trans policies. And because the officer didn't do that, Angel was able to win a court injunction, essentially blocking their deportation until a judge can send their case to judicial review, when there might be a potential do-over there where Angel's case would be reassessed using the proper procedure. And I think that's okay. The problem here is that the Canadian media misrepresented the case and heavily implied that the judge had found evidence of persecution of non-binary people in the United States, when the judge's ruling here was highly technical and narrowly focused on procedural fairness.
And in your opinion, what did media outlets get wrong in their reporting on this case?
Well, I think the way that they reported it, they tended to omit the technical nature of the case. And they really emphasized the fact that, the judge found that the immigration officer missed some evidence which may have supported the Angel's case. And what they didn't clarify here is that may have supported is not the same as saying the judge saying that this will have supported. And essentially, for many readers, they got the impression that the judge said, oh, you know what? Evidence was omitted that, would have supported Angel's case. But just because evidence is possibly relevant to a case doesn't mean that the judge finds it compelling. And so I actually ended up calling and speaking with Angel's lawyers, and Angel's lawyers confirmed to me very firmly that the judge did not make the determination that trans or non-binary people are persecuted in the United States, and they felt like the case had been misrepresented and that there had been misunderstandings by some of the journalists who wrote about it. I think also many of these media reports were, they included interviews with LGBTQ activists who really emphasized how this could be precedent setting. And when you use the term precedent setting in this context, I think it suggests this idea that a judge has recognized that non-binary people are persecuted. But really, there was no precedent that was set here because this was a pretty innocuous ruling about following normal evidentiary standards. But because the LGBTQ activists didn't seem to understand the case and the reporters didn't seem to understand the case, readers think that there was some big evolution in Canadian jurisprudence that had an effect on trans rights when really that's not what happened at all.